And workers being able to strike is an objectively good thing. It's one of the only ways that workers can exercise power over their own employers. Alrighty, guys, let's go ahead and get things out of the way. Before we start, though, I do want to let everybody know I will be at the Too Many Games convention on June 23rd to the 25th. I don't have a panel or anything there, but I will be playing some Commander games over in the Magic the Gathering area for anybody that's there and wants to fuck around and find out. That said, the Supreme Court did something real stupid recently, and we gotta go over that, because, of course, that's living in America is basically accepting that, hey, the Supreme Court has done something to ruin your life. So let's go ahead and get into that real quick. But first, let's get into the fan art section. The very first one we have here is from Cole Foxwell. There is no context given on that one, and I'm kind of sad about that. I love when artists give their stories attached to these. But thank you very much, Cole. I appreciate this pick, and I actually really like this take on the outfit. The more, like, One Piece-y take there, with the very, very, very fuzzy leggings. I do like it. Is really good. The next one we have here is from Simperoni. It said, first ever fan art here. I'm not good at slime or jello. Looks like here, not good at slime and jello looks, so here is a fluffy cat ball. Aww. He is adorable! I just want to throw him against a wall violently. Thank you so much for your fan art. As always, everybody, thank you all for your fan art submissions. If you want your fan art to be shown in a future video, the best way to do so is to drop it into the fan art section of the Discord. With that said, let's go ahead and get into the topic after you hit the subscribe button, please. I'd actually kind of prefer if you did subscribe. Subscribing is good, objectively. Okay. That's enough shilling for me. Let's go ahead and get into... In a blow to unions, Supreme Court rules that a company can pursue strike damages now. This means that the Glacier Northwest Incorporated can sue over its claim that wet concrete loaded onto trucks was rendered useless after workers walked off the job. So, okay. What's the story here? Well, basically, a bunch of workers went on strike, and the point of a strike is to inconvenience the employers. So when you try to say, well, it makes sense that if you damage company property, then you would have to be liable for the company property you damaged, the problem is the way the property was damaged here was that a group of workers went on strike while their trucks had cement in it. The only way to get the cement out of the trucks would be to either render it useless, harm the equipment, or finish the job that they are striking from. And workers being able to strike is an objectively good thing. It's one of the only ways that workers can exercise power over their own employers. So there's really no way to strike here without inevitably causing damage to the work trucks. The only other way would be to just, complete the job, in which case there is no purpose behind the strike. The job is done. What power do they have? So, by the Supreme Court ruling, and we're going to get into the actual article here, but my take before getting into the article is that by the Supreme Court ruling that the unions can be held accountable for the damages caused by the strike, that kind of opens the door for any company going forward to argue that any damages they take as a result of their staff striking, even if the damage is not equipment breaking so much as it is just a loss of revenue because people are not producing work, then they can try to recover those losses from a strike. This means that you could actually starve out unions completely, because a union has to have a certain amount of money that is accrued from union dues so that when writers go on strike, the union can pay the writers or the construction workers or whoever happens to be working and going on strike at the time. The union is there to make sure that they can go on strike and get paid. Most people in America work paycheck to paycheck, so the way to circumvent that problem, that power that an employer has over you, is so that the union takes care of your pay while you are striking, because we don't have, like, a striker's insurance or anything like that. The union is the striker's insurance, functionally. By opening it up to where any company could actually make their unions get in trouble, they can starve their unions out. Because now the unions have to be responsible for not only the loss of revenue to the workers, but the loss of revenue from the company. The unions functionally cannot have enough money to take care of the profits of the company as well as the workers. The responsibility of the union is not the profits of the company. It's the well-being of the workers. So let's get into why this has happened, because this is very, very screwed up. In a loss for organized labor, the Supreme Court on Thursday ruled in favor of a concrete company in Washington state seeking to revive a lawsuit against the International Brotherhood of Teamsters, alleging that a strike damaged its product. The 8-1 decision, written by Justice Amy Coney Barrett, means the company, Glacier Northwest, can pursue a lawsuit against the union in state court over an August 2017 strike in which drivers walked off the job, leaving wet concrete in their trucks. The company claims that the union is liable for what it says was intentional damage to its product. Again, might I remind you, in this situation, there is no real way to not cause damage to the product. The product is concrete. There is nothing you could do that would not damage the concrete. When concrete is in trucks, it is being constantly mixed so that it does not set in the trucks itself. Barrett, one of the court's 6 conservatives, wrote that a state court was wrong to dismiss the claims at such an early stage in the proceedings based on its concern that the claims conflicted with the National Labor Relations Act, a federal law that protects union activity. She says, because the union took affirmative steps to endanger Glacier's property rather than reasonable precautions to mitigate the risk, the NLRA does not arguably protect this conduct. Again, it's concrete. There is not a way to not cause that damage. There is not a way to stop the chemical reaction of concrete forever. Organized labor advocates had raised concern that a ruling in favor of the company could stifle strike actions by opening up unions to damages for claims for a broad range of potential losses. Employers can face losses that employers can face as a result of such activities. Liberal Justice Ketanji Brown Jackson dissented, however, saying the ruling risks erosion of the right to strike, which they are correct about. The thing about strikes, or not just strikes, the thing about any right, when the Supreme Court is the thing behind that is allowing that right to continue to be exercised in the United States, when the Supreme Court makes a judgment on something, that thing then becomes precedent later. The Supreme Court has to be very, very, very careful with anything that it does when it comes to their rulings, because their rulings get used as precedents in law practice going forward, not just for other courts, but for themselves. The Supreme Court has this thing called the super precedent, where previous rulings in the court can be considered unmovable and unshakable. This is important. And as many times as we meme on, hey, in a 5-3 decision, hey, in a 5-4 decision, hey, in a 6-3 decision, the Supreme Court has said you don't have a right to eat cereal or some shit. This is one of those situations where it's kind of scary, because even our liberal justices are like, actually, no, fuck the union. Jackson pointed out that the National Labor Relations Board issued a complaint after the state court ruling, charging the company with unfair labor practices and saying the driver's actions were arguably protected. By ruling in favor of the company, the court inserts itself into this conflict, proceeding to opine on the propriety of the union strike activity, despite not being the best place to weigh the facts. This case is Exhibit A to why the board and not the courts should ordinarily take the first crack at resolving contentious, fact-bound labor disputes of this nature. The dispute centers on an incident in which members of Teamsters Local 174 went on strike after negotiations broke down over a new collective bargaining agreement. When truck drivers walked off the job, the company says some of the concrete already in the process of being delivered was rendered useless. Again, that's how concrete works. There's no way around that. Drivers returned trucks to the company's facility, some of which had partial full loads on board. As a result of the strike, concrete was left in trunks and had to be removed to harden and then be broken up before it could be disposed of. Yeah, that's how concrete works. The union says when the workers returned the trucks, the cement was wet, and they left the drums on the trucks rotating, meaning that it would not immediately congeal. It was the company's decision to remove the concrete and then break it up once hardened. Glacier says it lost $100,000 as a result of failing to fulfill a contract on the day of the strike, and also claims additional damages. The company says it was able to do the previously scheduled work the following week. The Washington Supreme Court ruled for the union in December of 2021, saying that any loss of concrete was incidental to a strike and arguably protected by federal law. But Noel Francisco, the company's lawyer, said Thursday's ruling vindicates the long-standing principle that federal law does not shield labor unions from tort liability when they intentionally destroy an employer's property. Again, though, this was not intentional destruction of property. They did what they could. They left the barrels running. It was the company's decision to dispose of the concrete. The company had the wrong of it. They did the thing incorrectly. They made the fucking mistake. Sean O'Brien, general president of the International Brotherhood of Teamsters, criticized the decision, referring to the justices as political hacks, and saying the court had again voted in favor of corporations over working people by throwing out long-standing precedent. He said, "Make no mistake, this ruling has everything to do with giving companies more power to hobble workers if any attempt is made to fight back against a growing system of corruption." Notwithstanding the harsh rhetoric, Charlotte Garden, a professor at the University of Minnesota Law School who specializes in labor law, said the ruling isn't as bad as it could have been for organized labor because it does not directly threaten the right to strike. Now, I'm going to go ahead and say this right now. Anytime that the only thing you can say about a bad thing that has happened is it's not as bad as it could have been, none of that negates the bad thing that's happened. Let's go ahead and take a stubbed toe, for instance. Well, at least you didn't break your toe. Or at least you didn't get AIDS. That doesn't mean shit. The toe is still stubbed. We're not comparing the hypothetical scenario with what's happened. We're pointing out that the bad thing has happened. Let us move forward from that fact, please. She added it leaves open the possibility that unions could be on the hook for product loss that is attributed to things that the employer did after the union knew it was going to strike. For example, a union could be liable for a restaurant losing perishable food as a result of a strike if the employer did not know about the impending action at the time of the purchase, but the workers did. Again, it is not the employer's business. The union does not need to go like, hey, we're planning on striking in a few weeks, my guy, because our negotiations aren't going well. No, the union should be able to just go, our negotiations are not going well, so we are going to strike. Suck on it. It sucks for the company, I get it, but I am not about to be in favor of the faceless goddamn corporation versus the people who actually lay the groundwork for those systems to function. Business interests that are often in conflict with organized labor have been heavily critical of the labor board in the past. The Supreme Court's conservative majority has ruled against unions on several occasions in recent years, including a 2018 case in which the court said public sector workers who choose not to join a union cannot be compelled to pay a share of union dues for covering the cost of negotiating contracts. The ruling comes as the number of strikes has increased amid a renewed interest in some sectors in the protestations that protections, that's the word we're looking for, that union jobs can offer. The company was backed by business and anti-union groups, including the U.S. Chamber of Commerce, which said in a brief that the state court's findings that intentional destruction of property could be deemed a protective activity conflicted with the U.S. court precedent. Various labor groups and unions backed the Teamsters, which, you know, of course they would. If you're here on part of organized labor, then the organized labor just has the right of it here. Again, we're talking about concrete, a chemical reaction that cannot be stopped. And when the decision is made to walk off that job site because your employer is not treating you correctly, you being liable for that, your union being liable for that, is utter fucking madness. Not just because of the individual scenario in which we're talking about something that was purposefully hardened by the company and then broken up and removed by the company, therefore absorbing a loss they didn't need to fucking absorb. But on top of all that, we're talking about a Supreme Court decision that will be used in the future to try to strike out against labor again. And after it's happened once, bet your ass it's going to happen again and again and again and again. The power of unions in the United States has been slowly eroded. The need for them has increased as monopolies stranglehold more and more industries. But now we sit here on the 2nd of June. This all happened on the 1st of June. This all happened, you know, back 2018, 2017. But this court decision happened yesterday. So I guess we're going to have to see where this all goes. And yeah, no, looking at the writers right now, how's that writer strike going to go? It's a lot more shaky to argue that anything is damaged by the writer strike, but a sleazy enough lawyer could do it. Writers may have created Saul Goodman, but trust you me, Saul Goodman can throw the writers under the bus. That said, let me know what you guys think in the comment section below. Hit the like button if you haven't already. If you disagree with me about unions being a good thing, bitch about it in the comments. You're already writing your paragraph anyway. Hit the like button, everybody. Subscribe. Insert end video tagline here.